Welcome to today's hybrid workshop on navigating cross-border data rules. My name is Liam Jia. I'm the team leader of the EU SME Center. Today we are hosting this event together with our partner, the European Union Chamber of Commerce in China. We are sitting offline in the EUCCC's Beijing chapter office. Before I start, let me quickly give you a brief introduction on the USME Center. The USME Center, we are a project funded by the European Commission. We facilitate, assist small and medium-sized enterprises from Europe in doing business in and with China. The project was established already in 2010, and this is the 14th year and fourth phase of the project. We provide services in mainly these 5 aspects. To start with, we have a self-diagnosis tool on the website that provides a questionnaire to SMEs for self-assessment on their readiness towards China. We have a knowledge center where over 200 publications, including market studies, market reports, step-by-step exporting guidelines, as well as case studies and success stories can be found, covering all different sectors when it comes to exporting investments in China and to China. We also have an advice center. There is a frequently asked questions database published on our website, covering over 70 frequently asked questions by SMEs. We also provide a inquiry desk. SMEs and also intermediary organizations can submit all sort of business-related questions you might have. This will be answered by our in-house and field experts. We also have a training center where we provide face-to-face as well as online trainings with all the information we produce, covering all range of topics. And today we are doing one of these trainings hybrids. Last but not the least, tapping into the well-established resources of the European Union Chamber of Commerce here in China, we also have a SME advocacy platform where we collect the performance feedback from SMEs who are already operating here in China on the challenges they've been facing doing business here. We constantly voice on their behalf vis-a-vis the Chinese government authorities and policymakers in order to constantly improve the business environment for SMEs operating here in China. Moving to today's topic on navigating cross-border data transfers, we have a good lineup of speakers. To start with, we have Ms. Barbara Lee, partner at Reed Smith's Beijing office. We also have, as our second speaker, Mr. Nathaniel Rushford from Desjardins. Last but not the least, Mr. Tom Nonlist from Trivium China. After these 3 presentations, we'll also have a little Q&A session. So during the presentations, for our online participants, if you have any questions, please do not hesitate to type them down in the chat box. We'll have a chance to address these questions later to our speakers directly. Without further ado, allow me to pass the microphone already to our first speaker, Ms. Barbara Lee, the partner at Reed Smith's Beijing office. Barbara, the floor is yours. And if you wish to control the slides yourself.
Hi, good afternoon, everyone. Thanks again very much for having me today. It's really my great pleasure to be here today and our SME member with our member companies, and also to share some of our thoughts and discussions around the Chinese data regulations. So I'm sure for our audience today, so probably we have been all following very closely the developments in China in relation to data and cybersecurity regulations. because the data regulations has been probably one of the top three key points. Actually, keep a lot of CEOs or senior management of the companies awake at night, and there have been a lot of developments in China. So for European companies, so a lot of you probably have been familiar with the European GDPR. But the Chinese regulations actually are quite different and have some very unique regulations requirements. Oh, sorry, where are my slides?
I share it from this.
Okay, no worries. So yeah, so I can just carry on. And so for today's session, for today's discussion, so I probably will spend like 15 to 20 minutes very quickly walk through the Chinese data regime. So because we also got very distinguished guest speakers talking about some other matters in relation to data, like a cross-border data transfer. So I just start by setting up the scene, talking about giving you a very brief overview about the China data regulatory regime and briefly touch upon what key implications for SMEs for their operations in China. And also, last but not least, from practical perspective, what practical, pragmatic approach you'll be able to take for compliance and also for managing your regulatory and legal risk in China for your operations. So we can move on to the next stage. Next page. Okay. Right. So in China, as I mentioned, well, the Chinese data law is very different from the GDPR. So in China, we have three major laws, and normally we call it the three pillars of laws: cybersecurity law, data security law, and personal information protection law. So all these are three laws. National laws constitute the China's comprehensive data legal regime. So unlike GDPR, so where the European side has spent, 30 years probably, and even over that, to come up with the GDPR, and finally became effective in 2018. But in China, the whole process is much shorter and quicker. And so that has given the companies and especially SMEs where they do not have that cost or human resources to tackle the compliance challenges as a large MNCs. So those are three laws actually include quite comprehensive compliance requirements. And so we can take a further deeper dive at a later stage. But in addition to the laws, there are, in addition to the national laws, there are the implementing rules and also local rules, and also the guidance issued by the various industry-specific regulators. So those have altogether constituted and presented quite significant challenges for companies to comply with those requirements. We can move on to the next slide. Right, and also for the regulators, and again, that is also quite a mix of multiple regulators who have the power to oversight the data and the cybersecurity matters. So unlike the European, where you probably know more clearly like who are the data regulators in Europe, but in China, you do need to look at the regulations issued by multiple data regulators, and so you need to look at CAC and IT, and also the industry-specific regulators. And the challenge is that sometimes the regulators, different regulators, may have different views on how the data should be processed or regulated. And then that will cause more additional difficulties for the companies to tackle the already complicated China data regime. We can move on to the next slide. In terms of application, those are data laws as I mentioned, those are three pillars of national laws and the local regulations and the industry regulations actually apply to all industries almost. So basically, nobody is singled out where you can say, well, I do not have to comply with those regulations or laws. So for example, whenever you, as a company, you needed to collect the employee data for your Chinese entities, or you are handling consumer data, for example, for SMEs, we just discussed the European SMEs are looking to export the products like food and beverage, cosmetics, etc. to China. So they need, for example, especially by using the e-commerce, like when they sell the products a lot on JD.com or Tmall, etc. So they have been collecting a huge number of consumer information from China. Okay, so all those, the data, personal data collection and processing, and also to transfer the data outside China, you have to comply with all these comprehensive legal requirements under the Chinese laws and regulations. And then move on to the next slide, please. Yeah. So in terms of the data activities, and you can see from this slide, so the entire life cycle of the data activities are covered. So it's the laws and regulations will cover from the initial stage where you start to collect your consumer data or your business partner data or your employee data, and also down the way for processing, sharing, cross-border data transfer, or even at the last stage, deletion and destruction. And Chinese data laws, if you compare the GDPR and the Chinese data law, I think one of the very unique complications is that the GDPR basically governs just applies to personal data. But Chinese data laws and regulations cover both personal data as well as non-personal important data, for example, some industry data. The reason why that, because if you look at the rationale behind the Chinese data laws, so Chinese data law, not only focus on the protection of privacy, it also look at the data sovereignty and data governance. So that's why the protection of privacy is always intertwined with the national security concerns. So that indeed has presented a huge compliance challenges for companies, especially for international companies and their operations in China. And also some of our, I think Tom, so you're going to talk about the cross-border data transfer. So that actually is one of the most, I would say, difficult aspect, the most challenging aspect for international companies for their data activities in China. So move on to the next slide, please. Right, so for data localization, so given that other speakers will talk about cross-border data transfer, so I'm not going to bore you with the data localization very much. So just very briefly touch upon some key concepts when you need to handle the data locally, and also to look at whether your transfer outside China will be subject to any special compliance or requirements under Chinese law. So for some industries, from the Chinese data laws perspective, some industries are much more sensitive than other industries. So for example, if you are dealing with data in like the energy, telecom, or financial or automotive industry, and then the operators in those industries can be regarded as a critical information infrastructure. So in short name, CII. What does that mean? It means that you have to comply with the even higher compliance requirements in terms of data protection, cybersecurity, and also cross-border data transfer. So under Chinese law, when you need to transfer the data abroad, either important data or large volume of personal data, so you've got to follow one of those three mechanisms. So either you engage the CAC, the Chinese data regulator, for the approval for review, or you needed to adopt the SCC, so that is so-called standard contract clauses mechanism. And then you needed to prepare a huge number of comprehensive documentation and also to submit your documentation to the Chinese data regulator CAC for filing. And so those are, mechanism before the March this year. So basically, those are three mechanisms. Is one of them we have to adopt for your cross-border data transfer. But recently, there is some good news, which is the new CBDT regulations issued by CAC in March. So you will be able to enjoy some exemptions under the new regulation. So given that, we have other speakers talk about that, so I'll leave that to other speakers. So we can skip this one. Yeah. I think for this one, yeah, so probably just very briefly touch upon, so for the new exemptions, so I think from the business impact or implication perspective, given that the new regulations are provided with some very positive and welcome relaxations. So companies will be able to evaluate whether your data transfer scenario will perfectly fit into one of those exempted exemptions. And if you are, and then you'll be able to enjoy more freedom in terms of what model, what mechanism you will be able to adopt for your cross-border data transfer. So because for a lot of MNCs, a lot of European companies where you probably in your home office, you have adopted the European GDPR activity for cross-border data transfer. Because before the March regulations, so even though you have got your the European GDPR activity in place, you cannot basically replicate that in China for your China cross-border data transfer because of the Chinese rules that have its very unique requirements. But now under the new regulations, so if you will be able to, so based on your assessment, you think you actually, your scenario, your transfer scenario falls within the exempted scenario. And then you do not have to exactly follow the one of the three Chinese transfer models. And then you'll be able to continue to use your GDPR-based transfer model. So which actually is good news and will be able to reduce the compliance cost and burden for your company. So I think that is especially good news for SME. And also some scenario, for example, like cross-border e-commerce, cross-border payment, and the cross-border tourism. And so probably those are much more relevant to SMEs. So you will be able to specifically leverage the exemptions under the new regulations. So that is, I think could be some very positive development. Right. So for AI, it has been a buzzword since ChatGPT, and especially in Europe, like earlier this year, the EU just passed the EU AI Act, and also in China, the development of AI has also been very active. So in China, we have already got the regulations on generative AI and also algorithm. So for some algorithm, and so far there have been over 100 big data models have been filed by the Chinese authorities by CAC. And also following the same methodology as the EU. So China has also been very active in looking at drafting China's own AI law. So we expect the AI law, that's something it's a work in progress already. So hopefully we probably will be able to see the initial draft of the AI law for public consultation, probably, maybe later this year or next year, but you never know, because China's speed is always out of imagination. So if the authorities, the lawmakers want to move very quickly, and you'll be able to see, we'll be able to see the draft China AI law soon rather than later. And also in terms of collaborations, I think there have been some very interesting developments on international collaborations on AI. So China and France recently, made a joint declaration on collaborations on AI governance and also on investment on AI. And also China and the US just, I think last week or 2 weeks ago, the two sides have kicked off the talks discussion around how to manage the AI risk and also for better AI governance. And also more interesting in China is that the Chinese courts actually have been quite active in taking the proactive approach by doing trials for AI cases. So personally, I think, well, this actually has been quite interesting because, if you look at the AI cases in US or in Europe, actually China courts tend to be more advanced in embracing the new technology, trying to provide some solutions to resolve the cases or disputes around AI. So given the time constraints, we do not have time to have a deep dive in those interesting points. But yeah, so maybe we can find another time to talk about that. Okay, so important data, and I think it is also related to the cross-border data transfer. And also we can move on to the next slide because for important data, actually the free trade zones in China have been leading the way in drafting new regulations and trying to provide more guidance and clarity on what would be regarded as important data. Because important data, this concept was initially introduced, quite a few years ago, like in cybersecurity law, data security law, and PIPL. But there has never been any very much a clarity on what exactly the important data will be defined and determined. So that has created quite some uncertainties and difficulties for companies to address their compliance risk. But now, especially under the new regulations, the March new regulations, the central CAC and the central government has already granted the authority to the free trade zones. So the free trade zones, they have been acting very actively in responding to this new opportunity. So, for example, like Shanghai Lingang Free Trade Zone and Beijing Daxing Airport Zone. So they have all been very active in trying to formulating some catalogs or guidelines to help people, to help the business, and to understand and define the scope of important data. And just last week, actually Tianjin. So actually, this is the first one to publish the negative list for important data. And so actually, last night I was drafting my LinkedIn post talking about the new development around the Tianjin negative list. So yeah, so hopefully I'll when I have time, so I'll get my LinkedIn post online. So if anybody would like to take a look at that, please feel free to let me know. So we would expect not only these are three free trade zones like the GBA, the Hong Kong, Guangdong and Macau, Greater Bay Area, and also some other free trade zones, and have also been looking at how to improve the data governance regime, the pilot regime in their own free trade zone, to trying to build up a better data environment to attract foreign investment and also Chinese export-oriented business to set up their operations locally there. So yeah, so this is going to be some very interesting development to watch for the coming months. Right. Okay. So in terms of the so we talk about the key requirements and then the legal liability, etc. So very similar to the GDPR. So GDPR has imposed very strict legal liability for non-compliance. So the same thing we have seen in Chinese rules and regulations. So the Chinese data laws, PIPL, cybersecurity law, and data security law also provide for some very strict and serious legal consequences for non-compliance. So that means the laws do have teeth. So you do have to take proper compliance actions. So or otherwise you'll get yourself into the difficult position. So the liabilities actually are quite wide ranging. So it ranges from the monetary, the money fines. So like, for example, that can go as high as 50 million RMB or 5% of your company's last year turnover. And also the authorities can take other admin sanctions. So either, shut down your website or suspend your business operation or revoke your business permit, etc. And also the senior management of the company personally, they can be exposed to personal liability as well. And in worst scenario, there can be criminal liability. And so the criminal liability actually is not just something on the paper. Actually, there have been real life cases already in China where some companies and also the CEO or the general managers were put into prison because there was a very serious breach for the laws. So yeah, so the risk is indeed real. Right. Okay, so we can move on to the next one. So in terms of a trend, the enforcement. So the authorities have been very active in taking enforcement actions. So we have been seeing the authorities are have been doing the dawn raids, investigations, etc. And initially, I would say probably 2 years ago, most of the companies are called much more local. Chinese companies, but I think from last year, more and more international companies and FDI and FIEs actually were called. And not just large companies on the radar of the authorities, but also including small companies, even like some a food massage shop or etc. Or the food chain and some hotels and restaurants, etc. So yeah, they have been called. And so mobile app, so that has been probably one of the most targets by the authorities because our mobile app has been so widely used. So sometimes the app operators they just collect all the data, either you go to the restaurant to make an order, etc., and they ask for your information, ask you to follow their app or the official account. And so those are kind of a collection of personal information actually is not necessary. It does not exactly follow the necessity requirement under the Chinese law. So sometimes some companies tend to say, okay, so data now is a new oil for the digital economy. So no matter whether I'm going to use the data now, so I just collect the data as much as I can. But actually that kind of approach can present huge compliance risk for the companies because the authorities have been, for the multiple rounds of investigations and dawn raids, the authorities have exactly made the investigation to check whether the collection of the data is necessary. Because, for example, like you go to a restaurant to just, to order a bowl of noodles. So why do you need me to provide my personal information, right? So, and also like a facial recognition. So some hotels, so you need to do the facial recognition because when you enter, when you do your check-in. But some places, for example, like a zoo or you go back to your apartment, and so rather than using your card to open the door, and sometimes they ask for your facial recognition as a pass. So that kind of approach or practice actually can present compliance risk. So we have seen the courts and the Chinese authorities are very much targeted on those non-compliant practices. Right, so we can move on to the last one. So I think the last bit is next one is so we can move on to the next one. So next one is my last slide. And just some practical considerations to take into account to bear in mind. So how to address those compliance risks given the complications. So I think number one, it's very important to understand where you are. So by doing that, you definitely need to do a health check and to do like a data mapping to understand what kind of data you have collected in China, from China, and what is the nature of the data, how big the size of the data, And what is the data flow? Are you sharing the data with any third party or transfer the data block? And who is going to access to those data? So to have that basic understanding of your data collection and processing activities is a very important start to do your evaluation, to do the risk assessment. Because you can only be able to address your compliance issues after you have got accurate and good understanding about your data picture. And based on that, I think you probably can consider, how to design your data strategy, which is in line with your business priorities and needs. And also, China's data laws and regulations are evolving and such are faster speed because I would say probably China is the country which in the past several years I have issued the most data and cybersecurity laws and regulations. So you never get bored because those laws and regulations are come up like at a weekly basis. So especially just a little bit joke. So especially sometimes around Friday or Friday afternoon or before a long holiday, and then you expect that the CAC guys will probably will keep you busy during the weekend, and they will issue something very important. So you will not get bored. You will get yourself occupied with something. So that is something, basically in China, and you definitely need to keep a close watch on the regulatory and the enforcement developments, and also to take appropriate actions. And especially with the new exemptions and the relaxation more recently in China, I think it's also be good to look at, whether you'll be able to leverage some of the exemptions, because indeed, some of the exemptions actually can reduce your compliance burden. And I think that's probably especially useful and helpful for SME. So you definitely, because you probably are more tight on the budget for the compliance. So if you be able to leverage some of the exemptions, I suppose that would be a good news for the companies. Okay, so that's all I want to say today. So the last page is just, some kind of, yeah, we can move on to the next one. Yeah, just a list of some publications. So we have, my team and I, we have produced. And so if you want to add me on LinkedIn, so actually LinkedIn posts that we keep the updates more regularly than our publications. So please feel free to let us know if you want to receive any information. Okay, thank you very much.
Thank you very much, Barbara. Indeed, as you see on the screen, aside from Barbara's title at Reed Smith, Barbara is also serving as the Vice Chair of the Cybersecurity Sub-Working Group of the European Chamber, very frequent speaker at many of the European Chamber's events. So please be invited to connect further with Barbara. And moving on, apologies for inconvenience. We need to swap the orders of the next two presentations because our speaker from Zensera is not here yet. So we'll move on directly to Tom. If you don't mind, please take the floor.
Of course, thank you so much. It's great to be here. My name is Tom Nunlist. I'm from Trivium, China. For those of you who don't know us, we're a policy research consultancy. Basically, our specialty is kind of understanding how the policy sausage is made in China, and helping companies, like SMEs here, understand what that is. Thank you so much, Barbara, for the very detailed presentation that you gave. Kind of in the spirit of what we do, I would like to zoom out a little bit and take a contextual look at the big picture of cross-border data regulation. It's no secret, obviously, that compliance has been extremely challenging in the past few years. So why has that been the case? And more importantly, will it continue to be? Next slide. Next slide. Next slide. We're going to take a little bit of a look at the development first of the data security regime. I'd like to start off with something a bit conceptual. So kind of like how a law is made anywhere, right? We could break it into basically a three-stage process. There's conceptualization, so regulators recognize the need for, to regulate something in the market. Then moving to a formulation stage, you're actually writing those laws or regulations, and then to an implementation, you're going to apply them in the real world. Obviously, it does not happen in 3 clean steps, I think, anywhere in the world. But for China in particular, next slide, I think it's a much more blurry boundary between which is happening. And in some sense, all 3 are happening at once. It's a spectrum. And this kind of makes things challenging. Broadly speaking, lawmaking and enforcement are not perfectly sequential here. The path is not always linear. Frameworks are intentionally left open and undefined. Indeed, the question of important data that has come up now for many, many years is an example of this. And there's a general ethos, an unwritten thing, an ethos that I think of like learn by doing when it comes to applying laws in China. The impacts of that is, goals and intentions can change. Systems are evolving at the same time that they're being applied. Processes are maturing at the same time that you are, trying to deal with them. Enforcement timelines and specifics are unclear. All of that translates to a phrase you've probably heard before applied to China, is that compliance really is a moving target. And that is the fundamental reason why it has been so difficult to comply with cross-border data rules. Next slide, please. So taking a look at, kind of what that has meant for the cyber and data security regime, as, Barbara already went through the 3 main laws, CSL, DSL, and PIPL. I will spare you going through every single thing that's listed on this slide, but just wanted to give you an idea of really how long, this system has been in development. It's over a decade now. With these 3 big pieces, regulators, lawmakers are responding to a diversity of needs. And while that's happening, the political context is changing, the technological context is changing, the sort of view of the risk environment is changing. And so while regulators are trying to formulate the rules, their conceptualization is also evolving. And then there are implementation needs that are going on at the same time. So again, kind of all of these things are happening at once to one extent to another, and that is really kind of why this is difficult. Next slide. So in terms of specifically the cyber and data security regime, like taking our impacts from the slide before, kind of what has that meant? Calling out a few specific things. I think originally with the cybersecurity law, there was more of a tighter focus on critical information infrastructure, kind of these like big pieces that are very, very important to security. That has expanded to a more comprehensive view of security. Has been quite fleshed out. Originally, we had this, concerns with this concept of important data, a concept that kind of appeared very quickly in the law. There was not much discussion before that concept was created. Nobody really knew what it was. And over the last few years, we've seen this evolve into this 3-level scheme that, of course, I don't think regulators intended to go that way or necessarily knew how it was going to end up. But these are big changes. Obviously, seen big revisions to things like data identification rules. Obviously, we're here in part because of changes to cross-border data assessments. In March, differing messages when it comes to enforcement. We've seen like high-profile cases like Didi, but then also ignore rules. Again, with the application, the cross-border data security assessment applications. Those had deadlines that simply came and went without comment. And then, of course, this, sort of balance between or shifting between pressure and relaxation. Next slide, please. So, like with those sort of, wider messages sort of, in our minds now, what exactly has happened with the data export security assessments, again, that are from September 2022. So I think we should look first at what were the conditions present when those measures came out. So I've named a few bullet points here. First, it was really big pressure to implement amid rising geopolitical tensions. Again, kind of the origin of this system back in 2013 was responding to geopolitical risk. Those risks and the perception of them has like grown greatly in the past few years. And so there's really quite a lot of need, seen by authorities to implement this thing, to kind of get the train moving. This expansion that I've also already mentioned, from something that was a little bit more focused on critical infrastructure to be more all-inclusive. Some inherent technical complexity, when you're trying to do all of these different things, regulate, hardware and networks, regulate personal information, regulate non-personal information. There's many, many things going on here. Many incomplete details, of course, while they were trying to implement these measures. An understaffed bureaucracy, which may or may not be appreciated, but it's a little bit of an open secret that the CAC, which is really the sole agency up until recently that's enforcing these, simply did not have enough people to deal with the volume of regulation they had to do. And a services industry that's still emerging. So, we're still learning as we go. Indeed, the regulators themselves are learning as they go. So the outcomes of this, I think, are fairly predictable. Confused companies, inconsistent support, overwhelmed regulators, very significant gaps between central and local. If you hear about what the CAC said from this city to the next, not always the same. Missed deadlines, which we've mentioned, pervasive uncertainty. I think I remarked at the time when the September 2022 measures came out, how are they going to enforce this? How is this going to proceed? It seems like there's a lot of gaps. And the answer was, it was unable to. It was never going to go smoothly. And so what we see develop kind of in the year afterwards was the state of affairs was really untenable and a correction became inevitable. Next slide, please. So with that kind of in the March rules, what has changed and what has not? And we've already taken a look at some of the specific details, or you may know the specific details. All some like thresholds were changed. Like now we, have to look at a lower number of personal information before these are triggered. But yeah, looking at these conditions, the pressure is still to implement these rules, but it's changed to implement them smoothly. I mean, the very often repeated messaging from Premier Li Qiang, in fact, is that this needs to be friendly to the business environment. It needs to go a bit better, like emphasis on smooth implementation. In terms of the, all-inclusiveness of, the security mindset, it's now slightly less inclusive. Some of these things that are regular everyday business practices that maybe don't really need to be looked at are now not being looked at. They're exempt. In terms of technical complexity, in fact, it's still quite complex. I think overall the system remains intact. Conceptually, certainly, it has not changed. It's really only changed around the edges. In fact, I think there was a little bit of misreading at the beginning, some over-optimism about how relaxed, the March rules really made things. There's a bit more room to breathe on these still undefined issues like important data. We've shifted the workload. So this, the understaffed bureaucracy of the CAC, they now can rely a bit more on these experimental efforts in FTZs. It's technical things like green channels and the setting up of specific, I would call them like quasi-state. They're almost like consultancies that exist in the FTZs to like help you understand, how to do things. In particular, we spoke with some folks from Tianjin, and like they even said would be interested in assigning like specific people to companies in complex cases. So there's a lot more help going on or available, which is important. Although this system, the services industry is still emerging, again, we're still learning. We've learned a bit more, right? So the overall message here, the big picture impact of these March rules is the least tenable aspects of this system were dialed back. Right? The things that just couldn't be done, like looking at every single small company's exports of, personal information for business, for HR needs, like we're just not doing that anymore. And again, I would argue that, this was obvious back in September 2022, before we learned the lesson for sure. Going on. And this is positive news for SMEs. I mean, the regulatory focus has really been moderated. Again, common activities are exempt from oversight. Compliance thresholds have been loosened to really even exclude some smaller players. Greater attention, I think, shifted back to large players and sensitive activities. And this kind of overall shift towards a negative list approach. That's, very explicit, in the FTZs and in TNG, for example. But I think it also signals a mindset shift in terms of like enforcement orientation, like are we looking at every single thing and making sure it's fine, or are we going back to the more original idea, which let's figure out the things that are definitely risky and focus on them. Overall, again, the system remains intact. I do think there are fewer changes for large MNCs. We might add a little bit more detail on that later. Next slide, please. So finally, what are the ongoing uncertainties and what is the implementation path going forward? So one more time on our, cheesy simplified graph here. Where are we on, this chart? We're here-ish, moving out of formulation and more towards implementation. The overall framework is certainly stable now. I think the recent relaxations are an excellent sign of maturity, in the thinking and how this is going. I mean, it's like sort of mistakes were made and corrected, essentially. And I think that's great for moving into practical implementation, right? I think we have a better understanding now of what's going to work and how it's going to work. Again, this concentration shifting to the tougher challenges, ignoring the smaller ones. On this little, here-ish bracket, I would say we're moving a little bit more into the blue color of, having this mature system, but there are still, frankly, pretty many missing pieces and uncertainties. The CAC master regulations for implementing all three of the big foundational laws are still unfinished, which is frankly really surprising. We mentioned before the three-tiered system of general, important, and core data. That system is really laid down in these regulations. It's being implemented, and those regulations are still not finalized, which is a cause for concern. The CSL is now slated for updates. Again, there's a pretty big gap, not just in years, but also in policy realities and political realities and technological realities between when CSL and DSL and PIPL were created. That's going to be updated now. There's still, unfortunately, limited progress on sectoral rules. That, I think, depending on who you are, as an SME, that really might impact you quite significantly if you are in a sensitive sector. It's not only big players. There's a reliance on experimental policy, which in one sense is good. Okay, we're going to experiment and figure out what works, but experiments are what they are. Outcomes are uncertain, and the regulatory structures are still a bit immature. So, we are moving in the right direction. We're getting there. Next slide, please. That actually concludes it, but I think the message here overall, for a room full of SMEs, is the recent relaxations are good for you. They're frankly pretty great for you. They loosen things a lot. I think that is not the case for everyone that's facing this regulatory regime. Indeed, some of our large MNC clients at Trivium have told us point blank that the March rules really, in fact, don't impact them because they're so big and they're in sensitive sectors. If you are a small company, to some extent, for some people, maybe these problems are largely solved. Obviously, it's a case-by-case basis, and I will emphasize that I am not a lawyer, unlike our other guest here. But if you're in these sensitive sectors, or in the subject to these areas where there's especially unformulated sectoral rules, those are things you really need to look out for. I'll conclude my remarks there. Again, thank you very much for having me, and looking forward to the Q&A.
Thank you very much, Tom. Shall we first start with any questions in the room? Okay, I just received questions. Let me quickly read it out loud. According to the new regulations in March, there is a phrase of since the start of 1st of January of current year. So when should enterprise decide to take compliant actions? Does it mean that the enterprise only needs to adopt the 3 mechanisms when the transfer amounts actually reach the threshold, or before reach the specific amounts?
Okay, so I'll start. I think the new regulation indeed has reduced the threshold. And also firstly the size of the data sets, and also the time period that when you look at. So for how long the data sets will need to cover. So in the old regulation, so you need to look at the volume of the data starting from the 1st of January last year until now. But now, under the new regulation, you do not need to worry about last year. So you just need to look at how much the data you have transferred from the 1st of January this year, current year, until now. But you also need to look at, that actually the relaxation does not mean that if the threshold, the volume of your data below the threshold, and then you do not need to worry about anything. So you still need to look at, for example, if the data is regarded as important data. So it doesn't matter how much the size of the data. So you still need to go through one of the, basically the security assessment. And so that is number one. And also for CII, and Tom also talked about the CII, so the critical information infrastructure industry. And then you still need to look at the industry. And also for the complications for Chinese data requirements is that you definitely need to look at the data regulation actually beyond, the data regulations specifically, depending on the industry. For example, if you are collecting the data, if you are a pharma or life science company. So I know like a lot of SMEs actually CRO or labs providing support for large pharma companies. So in that case, if you are handling some special or much more sensitive data, so for example, like health data, or sometimes even more sensitive, such as genetic data, and then you need to look at the industry specific requirements. Because for health data, or sometimes for transportation, like mobility, and then for that type of special data, there are special industry requirements you need to follow. So it's hard to have one size fits all to basically just say, okay, so you are totally fine and you are in the same box under this size. So you need to look at the entire scenario.
Yeah, if I could add a few conceptual thoughts onto that. Thank you, Barbara. So I don't want to infer, what this particular question asker meant. But generally speaking, I think for companies, when it comes to compliance, to not approach things as what is the threshold and am I under it and can I not do anything? But instead ask yourself, in what ways could I be compliant, and how can I demonstrate compliance with at least the sort of spirit of the regulations? Because for one, there will be sort of continued lack of clarity, in the system, generally speaking, not just in this specific question. And also an attitude by the authorities that, indeed we're complying with a system that is fundamentally incomplete. And I would say trying to understand the spirit of the regulations in addition to the letter and going from there. But not asking, oh, am I under the bar? Can I slide under the door? I think that is, basically a bit of a wrong-headed approach in the system. Again, not to infer or put too much on the specific question here.
Yeah, I think just to add something additionally, yeah, Tom and I have had conversations about this in the past week or so, and I think we sort of agree that, and also probably agree with Barbara that the totality of the regulations need to be looked at, right? There are some new updates, and you can read the language in the new updates and try to infer some things. But like Barbara was mentioning, depending on industry, depending on size of your company, what the company is doing, there are other there's other legal language and other regulatory language that needs to be taken into account, and this is produced at a ministry level, sometimes even a local level around various types of businesses. And so like Tom said, don't think that these easings of restrictions just mean that a company can all of a sudden do what it wants. There still needs to be some significant internal compliance work done.
Thank you. And I think we, in the meantime, already have a few questions from our online participants. I'm reading out the first one. What are the thoughts of our speakers on the role of national data administration in the current context? The original aim of the creation of the national data administration was to send a pro-business signal.
Yeah, if I could start on this one, I've looked very closely at how the National Data Administration has grown up so far, and this is a really good question. I would make 2 points in here, in the context of thinking about compliance. The first one is that the compliance authority is really still with the CAC. So, the NDA doesn't really have any say, in particular over, kind of what data goes in and out of the country. It can certainly advocate. It can do other things like try to ink agreements with other countries. The international engagement is part of its purview, but when it comes to, direct oversight of companies, that's the CAC, and the CAC's mindset hasn't changed. What's more important to look at than the NDA is what are the sort of higher level authorities, like Li Qiang saying, and Li Qiang is saying, very clearly to the CAC that things need to be relaxed for pro-business reasons. The other point I would make is that the NDA is really strongly focused on getting things out of data, on building up the data economy versus locking things down. That's not a brand new idea. I mean, those goals were originally also owned by the CAC, and now they're split between these two agencies. So we have more, an agency that's solely responsible for this, rather than one that's responsible for both sides of that coin. I think generally speaking, that is good in terms of the security versus business question. However, I would also point out that the NDA's focus right now is very much domestic. So, and specifically, I would say like state enterprises. So what are we doing with data that's in SOEs and data that's owned hospital systems and things like that? How do we leverage the resources that we have now? They're China's chief data officer. That's who they are, right? The international engagements and thinking about cross-border trading and stuff, absolutely part of their purview. I would say, and it is important, but I would say it is the less important mission than focusing domestically. That said, I think they are an important advocate for this. They are operating, kind of in the FTZs with institutions like the data exchanges that are trying to facilitate things like this. But again, CAC is really still that authority. I hope that answers your question. A little bit wandering around. So
Yeah, I totally agree. I think NDA because if you look at where did NDA come from, so actually it came from NDRC. So basically, you know, if you look at the origin of the NDA, so no doubt they very much are focused on development of China's digital economy. But I would say, well, I totally agree with Tom. Like, you know, from the compliance or from investigation perspective, CAC still plays a very central and important role. But we would expect NDA and CAC, you know, down the road that they will work closely with each other because basically they are two sides, you know, on the scale. So probably if we look at, you know, the a little bit shifting of the approach, like starting from this year, if you look at last year or even year before, it sounds like the authorities are much more focused on the data security. But of course, economic development is still important. But you know, when you look at the focus, actually, the security actually definitely is on the higher side. But now it sounds like, you know, the government is trying to strike a much more balanced approach. You know, so basically economic development, especially the government is trying to boost the economy recovery. So digital and the data assets has become, you know, actually one of the fifth most important assets in China. And so that's why NDA, so they have been given a very important role to play to trying to leverage the value of the data. And also by looking at the new data exchanges are setting up in Beijing, Shanghai, all the major cities in China. And also starting from the 1st of January this year, the new regulation talking about, you know, the companies actually will be able to introduce and include the value of the data in their balance sheets. So basically, that's a very important sign, very important development where the companies will actually use the data as a kind of, you know, the assets either to borrow the loans and also to improve your creditability. So moving forward, I would expect NDA and CAC they will work together.
Thank you, Barbara and Tom. Anything to add online, Nathaniel?
Yeah, I think and you know, I'd like to also ask Tom and Barbara if, you know, for feedback on this, but my impression of what's happening with the NDA and CAC right now, and also data exchanges, is I think regulators are trying to peel off some of the responsibility from CAC so that they can focus very much more on enforcement and security issues. And so the commercialization and monetization of data is being peeled away from there. And so that's why we see things progressing with the NDA and, you know, the data exchanges and things in the FTZs. So I think it's an interesting development right now. There's the governance of this is evolving pretty quickly.
yeah, indeed. The NDA like directly took a number of duties from the CAC in the government reorganization in 2023. And so, yeah, indeed, that does allow CAC to focus more on enforcement. I think they were already pretty focused on enforcement. So I think the bigger impact is to put, you know, get more energy and more focus on the economic side, right? So again, I think like as Barbara said, rebalancing that thing. It's like we've had the ideal from the genesis of the CAC. The CAC always had development as part of as under its purview since 2013. But I think the security mindset there maybe perhaps led the development parts to be given short shrift, you know, by that agency. But now we have an agency focused on that, and it's, as Barbara said, under the NDRC, which is the development agency. So good news for the other side of that coin, and we'll see more daylight.
Thank you. In the meantime, We have a very specific question from online. I sent an email to our clients in China from Europe. We measure open clicks, etc. Are there any specific rules for this?
So quite specific, yeah. Well, I would say because for, if you just send general emails to your clients and customers, etc. So if you just measure the clicks or open, because well, I think probably I would first start by you do have your customer's email address, right? Otherwise, you will not be able to send the emails to them. So actually, their email address will be personal information under Chinese law. So I think probably you need to look at the starting point when you start to generate their email address. So whether you have got the proper the consent or the notification or got your privacy policy in place. I think that actually is a more basic fundamental issue you need to consider. But if we just look at open or click, if that is does not point to individuals, so actually it's arguable whether that would be regarded as personal information. So if it's not personal information and also it's not, I do not think that would be regarded as important data, unless your customers indeed are in very special sensitive industry. And I think that should be fine. But I probably would suggest you rather than just look at the clicks and the open, and you probably need focus more on your to have a step back to look at your practice when you started to collect your customers' email address, etc. Because at that point there is definitely the compliance action, compliance step you need to do.
One thing that occurs to me, I've never thought of this question until just now, but I believe GDPR may have rules about this, about like legacy mailing lists.
Oh, right.
So like, what if you have a very large list of Chinese clients, but those were collected before PIPL and perhaps are, where, would violate the regulations now. What do you do? I'm not really sure, and that occurs to me as potentially a relevant question, just kind of adding on to your concerns.
Yeah. Well, it's a good question. It's an interesting question.
Yeah, I don't know the answer to that. Uncertainty, folks.
We have more questions from our online audience. Next one, my understanding is important data is on state-owned companies, hence originally. Foreign companies usually do not know what is important data, and they just need to follow their customers or partners' classifications. Is my understanding correct?
Yeah, if I can keep holding the mic. That is incorrect. So the correct-ish thing is that state-owned enterprises are perhaps more likely to have important data. So for example, there are no foreign electricity providers in China. So, that's going to be all state-owned stuff. But there's nothing about in the definitions of important data that, indicate who owns it. In fact, the sort of origin of the concept is that it is sensitive in and of itself, no matter who possesses it, and there needs to be a regulatory structure that looks at, the what of the data and not the who has it. So again, private companies, foreign companies are less and less likely to have important data, but by no means is this something that's exclusive to state-owned companies.
Yeah, I just would like to add that I totally agree, because for China, for the important data, it's not who owns it. Actually, if you look at the definition, well, even though the definition is vague under the laws, but if you look at the definition, actually the Chinese concept very much look at the consequence of the data. So if the data, if there's a breach or, the cyber attack and misuse of that data, that can have a very significant negative impact on China's national security. It doesn't matter who owns it. It's in the SOE's hands or private companies' hands or in MNC's hands. So it does not matter. So I would not say, if the data is not in the hands of the SOE and then you'll be safe. I do not think so. So you still need to have to look at the specifics of the data.
Yeah, I think that's a very important point, and something that that we discuss with clients a lot is that how we classify data has a lot to do with potential risk of harm, whether it's to individuals or national security. So it's a downstream analysis that we need to look at when dealing with how to secure data, how it needs to be classified, things like that. So important point. Yeah, something to remember.
Thank you. Moving on to our next question. Hi, suppose we have a SAS system built up by cloud app and database. The system is already running worldwide except China. Do we have to put everything in China or just customer relevant data? Our business is infrastructure related. Thank you. Infrastructure.
So I can take a try of this one. Think of cloud indeed can be quite challenging because depending on where your server of the cloud is hosted. So as I understand from this question, given that the cloud, the SaaS service is not available in China, so I suppose probably your server is hosted outside China. So if you are going to provide the cloud, the SaaS services to customers based in China, so basically that means your customer you will need to get your customers' data extracted and transferred to your server outside China. And in that case, under Chinese law, that will trigger the cross-border data transfer. And then you will need to look at, what the mechanism, the cross-border data transfer mechanism you have to adopt. So under the new regulations and the March regulations, actually, Chinese data law never means that you have to store locally everything in China. But you definitely need to make analysis and you need to make a proper assessment whether some of your transfer is subject to the cross-border data transfer, like the security assessment or SEC, and also under the new regulations are given exemption. So some of the transfer scenarios are actually exempted from those three models. So which means actually you will have more choices and more freedom to transfer the data abroad. So, but you still need to do your baseline compliance work. So for example, if you are collecting personal data from China, you need to give a proper notification. You need to have the proper consent depending on your transfer scenario. And also for, I think some also good news, which is not directly relevant to data, but I think relevant to this speaker's scenario. So for cloud, actually from the telecom regulatory perspective, just last month as well, MIT, the China telecom regulator, just issued a new regulation where for cloud service provider, and you will have a much better market situation. So you basically actually can set up your office in China, because before cloud is very much highly regulated. So under the old rules, and you can set up your JVs, and you cannot have movies to do cloud. And in the past, you can have JVs, but cloud service is a value-added telecom service, and you need to apply for the VAX license. It's very hard to get the VAX license. But now with the new regulations, so number one, that the market entry barrier has significantly been removed. So that is number one. And number two is that as far as I have heard, the process and also the chances of obtaining the fast license actually is much improved than before. So hopefully, that information would be something useful for your situation.
I can add an anecdote. Or Nate, you can go first if you want to talk.
I was just going to say that, yeah, when it comes to the MIT catalog, like was mentioned, there wasn't really ever sort of an explicit ban on foreign companies entering that type of market. They just weren't ever really granted licenses, right? It was, very difficult to impossible to grant licenses. And so I think recently, within, the last month, now MIT has explicitly changed they've reduced the limitations on foreign ownership and foreign investment into cloud services. So that's actually quite big news that has flown under the radar a little bit.
Oh yeah, so just to supplement this with an anecdote that I heard from a company a few months ago. Basically, this was a global brand. And so speaking directly to this question of the difficulties of running worldwide software systems, cloud-based systems, it can be quite challenging. In this case, in this anecdote, it was the cybersecurity system. So, that was run on a global basis from a global security operations center. And as many multinationals do, whoever is in charge is, wherever it's working hours, right? And so they wanted to have China integrated into the system for many reasons. Obviously, it's cheaper and more efficient, but from their perspective, also more secure because they have people who are awake and doing the job all the time. And they just couldn't do this. So, it was just not approved, not allowed. And so, again, I can't speak to every single type of operation you want to do. I can only give limited details about this particular case. But these types of anecdotes, heard them more than once.
Thank you. Next question. Article 54 of the PIPL stipulates a general data audits requirements for personal information processors. Is there a format or a standard procedure to follow in order to complete such data audits? I understand that the CAC standards PIA report is for the cross-border data transfer scenario. And after the March rule, only larger scale data processors shall comply with such comparatively complicated PIA procedure. Thank you.
Right. So I can start with the second part of that. I do not think the PIA report, the CAC standard PIA report, just apply to large processor. But actually, the primary award to comply with the PIA actually is not on the processor side. It's actually much more on the controller. So suppose I assume that you are a processor outside China, I suppose. So probably you are receiving the data from your data controllers who actually is based in China and exporting their data to you for you to process outside China. So if that is a scenario, so basically the Chinese, the data exporter based in China, they have to finish the PIA report and to submit the PIA report and assign the SEC contract to the Prudential CAC for the CAC filing. So on your side as a processor, of course, you need to provide support and collaborate with your customer, so which is the data exporter in China. So you're required to provide some information expected and required under the PIA report. But most of the work actually will be done by your data controller, which is a data exporter from China. So that's my quick thought response to your second part. So for your first part regarding the personal information, the audit for personal information processors. So for audit, China has introduced a draft regulation for data protection audits. So that audit, that requirements or draft requirements, regulations are still not finalized yet, but it has gone through the public consultation. So if that regulation become finalized, and then we will have more details and to follow in terms of the audit. I think the well, just for some informal information sharing, I heard the audit regulation probably it's closer to finalization, because given the security assessment and SEC, actually CAC they just have the workload, which is beyond their capability. And so by using the third party, the professional third parties to help with the audit, actually that will help the companies to do self-regulating and also to reduce the compliance, the investigation burden from the CIC side. And also so far there are a few the Chinese state-owned institutions which have been granted the license to do to help with the certification, even though it's not audit, so they call it a certification. But I would say probably the certification and audit, down the road when the audit regulations are finalized, so probably you'll be able to leverage some of the requirements or the current practice of the certification. So that's my quick thought.
A little too operational for me on this one.
Yeah, I think in terms of the third party, authorized auditing organizations, we're talking, for example, in Shanghai, we're talking maybe 3 or 4 companies that are allowed to do this, that are registered, and so the burden and sort of workload is expansive for people trying to get, for example, MLPS certification, things like that. So yeah, I think ideally there would be a bigger list of companies allowed to do this, because it's required under various regulations. One thing I did want to mention that Barbara touched on in terms of foreign companies working with companies in China, collecting data and exporting it through sort of ordinary day-to-day business. One thing that I run into a lot is companies with, let's say, a headquarters in Spain or elsewhere in the EU. They don't have an entity in China, but they do business with Chinese companies, and get email addresses, various like lower level types of personal information. Now, of course, the foreign company is not really, without an entity in China, not really subject to jurisdiction here, right? But what I've been seeing a lot more of recently is the Chinese companies actually demanding from their foreign partners information about how they secure data, whether they're GDPR compliant, all of these sorts of things. And so what we've ended up doing is putting together information packs for foreign companies that are dealing with Chinese data collectors and data exporters to the foreign companies. So again, whether they're subject to jurisdiction in China is a secondary question. It becomes more of an operational sort of commercial issue for these companies. So that's one of the bigger impacts that I've been seeing in terms of just sort of day-to-day sales, BD, operational stuff for SMEs recently.
Thank you. As I'm clicking away the questions, we are also having more coming in. Unfortunately, we're running out of time, so I would say maybe we try to take 2 more questions. Is there a list of clear clarifications of definition of important and sensitive data?
Nope. That's the short answer is no. There has been progress on this. So the Cybersecurity Technical Standards Committee called TC 260, if you're interested in that. Recently came out with the national standards for how this is done. But the short answer is there's a framework that is qualitative. It's descriptive. I believe, as Barbara mentioned, it's like risk assessment focused. So what could happen if this data blah blah, and there's various categories that are kind of listed out. But this process, it's not going to be, there's not going to be a list basically that's at the national level like this data is important or sensitive. It's a process that's set up that will then be done by ministries, also now by FTZs, by other local governments. Companies have a big piece of responsibility in this. Like they also have to look at these, these frameworks, look at what their own data is, and try to figure it out a little bit, as was described to us by an official, I think it was from Tianjin, that it'll end up being a little bit like taxes. So like, you do your taxes and you submit them to the IRS and they, confirm that these are correct. So you will do sort of inventory, based on these standards yourself and then work with the regulators to do that. That's a bit of the long answer, but yes, it's a framework that will kind of play out and be built up. In my view, my interpretive view, I would also say that, what we're seeing is the creation of a normative system. And so over a long time, there will be industry norms that are formed over what is important and what is sensitive and where the kind of thresholds are. But that might take quite a long time for that to firm up. And it's, I think, an inherently, not a very bullet pointy type of process. I know that's what everybody's been hoping for since 2016, but not going to happen.
Yeah, so one thing I would add about that is that Tom's right. We're in the process of creating a normative system. And because we're in the middle of that process, there's actually quite a bit of room for companies and chambers of commerce, things like that, to have an open dialogue with some of the regulators about these issues. And so I think that's something that doesn't get discussed enough. Is there actually is room to maneuver. There's room to sort of shift certain things in certain ways. We've seen that over the past couple of years. And I think that's going to continue as the sort of the framework is evolving. I've actually been pretty well surprised, pleasantly surprised by open dialogues with people from CAC, from MIIT. There's actually a little bit of room for dialogue when it comes to this stuff. So that's something that I think companies should keep in mind.
Thank you very much. I think we'll stop here because of time constraints. If you have any further questions, you are invited to write to us here at the USME Center at the European Chamber of Commerce. We'll try to forward the questions to our speakers and get some written answers for you after the event. Before we stop today's session, please, I invite all our online offline participants to take a few minutes of your time to conduct a quick survey to give your feedback to today's events. Your feedback we value a lot to keep improving our performance for the organization of such events. Last but not least, I suggest everybody give a big round of applause to our three speakers, Tom, Nathaniel, and Barbara. Thank you for your sharing today.
The audience at triviumchina.com. We do have daily newsletters if you want this kind of knowledge in your inbox every day.
We only allow these advertisements because Tom gave an very interesting speech. Thanks. Thank you. That is the end of today's session, in case you missed a part of it. we will also have a recording uploaded to our website, of course, with the consent of all our speakers. Thank you very much. Please be invited to stay in touch with us at the EU SME Center for our future activities. Thank you.